Hello, good morning, students. Please subscribe the channel, drop a like, share, and comment. This is Shree Vishnu Art Press publication, exercise number 11 and 12 on the speed of 160 words per minute. Start. The applicant bank next submits that there is no direction in the judgment of this court dated 16/5/2008 that the tainted societies will have to file civil suit and the FDRs invested as per the directions of this court will be subject to the outcome of the suit. It is also submitted that pursuant to the judgment passed by this court, the societies involved in the Indian bank matters have raised demand notices calling upon the banks to make payment mentioned in the demand notices, and if the demand of the societies is accepted, then that would amount to double payment without there being any protection to the bank. The applicant bank also submits that, as per its understanding from the text of the judgment, the bank should proceed on the basis that if the tainted societies are innocent, and thus to inform them in regard to the matured amount as on date, and then to invest the said amount in the bank in the form of FDRs. The fate of the invested FDRs will be subject to the outcome of the criminal cases as well as civil cases which may be instituted by the societies. In para 20 of the judgment, the direction that banks and CBI shall sit together and identify cooperative societies which are in no way involved in scam has been issued on the assumption that CBI has investigated matters pertaining to all cooperative societies, and thus innocent societies can be identified and the amount may be paid to them. The submissions of the applicant Indian bank pleaded in these applications that there was no CBI investigation or case pertaining to the matters of Indian bank have not been brought to the notice of this court at the time of hearing and disposal of the appeals filed by the Indian bank. Undisputedly, there was no occasion for this court to labor hard for issuing such a direction pertaining to the cases of the cooperative societies depositors which are not in any way involved in the scam. Thus, applicant Indian Bank has misrepresented the facts before this court at the time of hearing of its appeals, and now, after realizing its glaring mistakes, these applications have been filed for seeking clarification of the directions. Now, in the background and on reconsideration of the factual situation, the direction contained in para 20 of the judgment to the extent that the bank, with the assistance of officer of the Central Bureau of Investigation, should make all attempts to ascertain as to which of the cooperative societies and cooperative banks are in no way involved in the scam, shall not apply to the cases of the Indian bank. The Indian Bank, however, in the interest of cooperative societies whose FDRs are lying in deposits and availed the loan facilities, shall on its own identify and ascertain the societies who are not involved in any CBI investigation or case, and on such ascertainment and verification, the cooperative societies depositors shall be informed regarding the maturity of their FDRs. Challenge in this appeal is to the judgment of a division bench of the Calcutta High Court disposing of the writ petition, the appeal, and the application filed with certain modifications. On the allegations that there was insertion of a variant element in the meter to bypass recording of actual consumption, first information report was lodged by the personnel of the appellant board. The provisional assessment was made, and thereafter there was disconnection of electricity supply. A writ application was filed by the respondent number 1 making grievance that the disconnection of the supply was wrongly done, and the provisional assessment as made claiming rupees 2,50,046 on the alleged ground of theft of electricity and or tampering of the meter was not sustainable. Learned single judge of the Calcutta High Court disposed of the matter in writ petition, whereby and whereunder the appellants were directed to restore electricity supply on deposit of rupees 20,000 by the writ petitioners. The appellants questioned correctness of the order on the ground that the disconnection of supply line was effected on 24/1/2006 in terms of the Regulation 52 of the West Bengal Electricity Regulatory Commission. The division bench referred to Regulation 52 and observed that the appellants have got right to disconnect supply line of electricity on fulfillment of the conditions stipulated, but the same is required to be done following a particular procedure. It was held that due procedure was not followed. The division bench held that under Section 126 of the Concerned Electricity Act 2003, the writ petitioner had a right of filing an objection thereof, which has been filed by the writ petitioner under Section 126(3). The appellants are required to pass a final order after giving a reasonable opportunity of being heard. The writ petitioner also has a right to prefer an appeal under Section 127 of the Act against the final assessment order. The division bench, therefore, permitted the parties to pursue the remedy. It was, however, held that the disconnection of power supply was contrary to and was in breach of Regulation 52, and the writ petitioner was, therefore, entitled to be compensated. Accordingly, the cost of Rs 25,000 was imposed. Learned counsel for the respondents submitted that the High Court has taken note of the factual scenario and the legal principles applicable. The final assessment in any event is the subject to challenge. Since the final assessment has been challenged, we feel interest of justice would be best served if the same is disposed of in accordance with law. It is open to appellant board and its functionaries to highlight before the concerned authority as to the maintainability of the appeal on the ground of alleged delay. It is needless to say that the said aspect shall be considered by the appellate authority. Let the appeal be disposed of in accordance with law without being influenced by any of the observations made by the High Court in the impugned order and by learned single judge.